My name is Matt Arnold. I represent myself as a citizen and also the organization For the Bench Colorado, which is a nonpartisan, nonprofit organization dedicated to restoring transparency and accountability to our third branch of government, the judicial branch. I ran a campaign this last election cycle dedicated to reminding people that they have a right to vote on judges and providing information about the judicial branch, primarily the Colorado Supreme Court, but also in general, judges who are appearing on the ballot. Certainly have an extensive amount of experience, most not terribly positive, with the campaign finance regulations and the burdens that are imposed upon citizens who wish to become active in the civic and political process and exercise their rights of free speech and free association under our United States Constitution and Colorado Constitution. Again, rather than rehash all of the particular points submitted in my written comment, I'd like to just highlight a couple of things and talk about some of my personal experiences that are relevant to this rulemaking. I rise, first off, in support of the rulemaking and would actually urge you to go beyond that and also tackle the issues of tracking individual contributions. Clearly that would be more consonant with the intent of Amendment 27, which became Colorado Constitution Article 28, which was to disclose large contributions by special interest groups or wealthy individuals rather than impose an additional burden on groups that were receiving small individual contributions and really imposing a huge overhead, really, and in essence, really a poll tax on political participation by individuals wishing to get involved. The burden of reporting individual contributions and tracking that, as Ms. Shea pointed out, and probably some other people have pointed out before that, really is quite extensive. It's not a big deal for well-established groups, larger organizations that have the infrastructure already in place and the legal knowledge already in place and the experience of dealing with these regulations and reporting processes to track that. It's not as big of a deal. But for small groups, such as Ms. Shea's organization, such as my organization, my organization essentially consisted of a boy and his dog, to collect all this additional information. It really is quite extensive and it is really quite burdensome. So just wanted to point out again that rationale for adopting this amendment in the first place was not to burden individual citizens or burden groups composed of individual citizens from participating in the process. It was essentially to try to minimize quid pro quo corruption or, quote, disproportionate influence on the process. There is no justification, either practically or constitutionally, for levying that burden on groups that consist of individual citizens receiving small individual contributions. So I wanted to point that out. Again, some of the practical considerations that are specific to groups that are receiving contributions or participation by individuals. The disclosure requirements not only exert an overhead on the groups involved, but they exert a chilling influence on participation in the first place. If I had a dime for every attorney who'd come up to me over the last 2 years and said, I support you, I love to contribute, but I can't have my name out there because I will be subject to retribution from clients and the judges, I could have easily funded my campaign in a very profligate manner. That is a problem, because essentially what these requirements are being used as is a tool to suppress political speech and suppress participation by individuals. That's a problem. Also, of course, the reporting requirements imposing that financial burden. The fact that you either have to spend a ridiculous amount of time and energy tracking all the contributions, summing them all up, collating them, and then submitting the report, which the reporting process alone is not terribly user-friendly, as I'm sure everyone in this room understands. I first attempted to do this solo. I spent nearly a week, and this was with very, very low levels of contributions at that point, putting together the report, submitting it, and getting it in just slightly over the nick of time on the date that it was due. And the one time that I had to request a waiver and got it was for the $50 that I would have otherwise been fined for missing the deadline just because the format I originally submitted it in wasn't the proper format was on that first filing. Subsequent to that, I decided it wasn't worth my effort and my time and hired out someone to do that campaign finance reporting and the financial tracking for me. Well, that's an expense. That is money that could have been more effectively spent in getting the message out. So the fact that now, because of these reporting requirements, I had to either spend a ridiculous amount of time doing it myself or contract out, as Ms. Shea pointed out in her testimony, before really reaching a level where I could afford to do so, is problematic. It is an undue burden on participation in the civic and political process by individuals and small groups. So that is an issue. Also, again, these disclosure reporting requirements, because of these barriers to entry, tend to restrict participation in the political and civic process by well-established, well-funded organizations. The very definition of special interests that Amendment 27, Article 28, was intended to do away with. So we've had a perverse effect of this amendment, this constitutional amendment to our state constitution, imposing these requirements with the intent, and I believe well-intentioned by at least some of the people, to open it up, to ensure that people had information, has had the perverse effect of making it more difficult for information to get out there. And the organizations that are participating in the process, the well-heeled groups, are able to come up with subterfuges and ways around it in any case. I don't know if Mr. Gruskin bothered to show up and testify in person, but I noticed that he submitted 2 written comments in opposition to this new rule. Ironic, because Mr. Gruskin, in the particular instance with which I'm very familiar, set up a 501c4 organization not subject to Colorado campaign finance reporting and disclosure requirements, spent a large but undisclosed amount of money from wealthy contributors, special interest groups, and other organizations disproportionately influencing the political process, yet subject to none of the disclosure or reporting requirements that were imposed upon citizen groups. I find that ironic, at least, and reprehensible in a larger sense. And other organizations did the same thing. The Know Your Judge campaign, consisting of 4 major organizations: the Colorado Bar Association, the Colorado Judicial Institute, the League of Women Voters, the Institute for the Advancement of the American Legal System, spent easily double the combined total of the contributions and expenditures of my campaign within the space of less than a month. But were subject, according to their interpretations and their very clever way around the law, to none of the disclosure or reporting requirements that individual people or small groups were subject to. Also problematic. Another aspect of that, of course, as I believe Mr. Choate pointed out, is the fact that groups, even if they comply with every single rule and regulation on the books, disclose every contribution, disclose every expenditure, make every reporting deadline, are still subject to attack in the courts by external groups that file campaign finance complaints. And again, another one of these groups, the so-called Colorado Ethics Watch, represented by Mr. Toro, and again, I don't see him in the room, but he also submitted a written complaint, are of course subject to none of the reporting or disclosure requirements of other groups. So we're treated with the spectacle of well-heeled, well-funded, well-established special interest groups collecting large amounts of money, spending large amounts of money to disproportionately influence the political process, yet subject to none of the reporting or disclosure requirements. problematic. I think this not only makes a mockery of our campaign finance rules and regulations, I think it also makes it much more likely that individuals will come up with their own ways around the rules and regulations. And again, this is corrosive to our democracy. It's corrosive to the rule of law. It's corrosive to the very purposes that were at the basis of Amendment 27, which became Article 28 of the Colorado Constitution. Very problematic. To make it an analogy and sort of put this in historical context, under Colorado's campaign finance rules and regulations, the 1960s civil rights movement could not have existed. They would have had to file all sorts of reports and disclosures identifying individuals who were supporting them. Those individuals certainly would have been subject to retribution, either physically or financially, or both. And it is quite clear that the rules as they exist are used more as tools to intimidate, harass, and suppress political participation than they are to enable information to get out there about people. In a word, the attack dogs, fire hoses, and truncheons of Bull Connor's police have been replaced as tools of intimidation by the rules, the lawyers, and the bureaucrats that enforce and abuse Colorado's campaign finance laws. So for that reason, I rise in support of the rule to at least alleviate some of the worst impacts of that. I believe that it is appropriate to raise the threshold of the aggregate contributions before these disclosure and reporting requirements go into effect, and again, in consonance with the intent of Amendment 27. And I further urge the Secretary to consider raising the threshold for reporting individual contributions to a more appropriate level, also in consonance with the intent of Amendment 27, Article 28 of the Colorado Constitution.